right, thank you, counsel. All right, our second case on the docket today is case number 18-1730, Thomas G. Moore and Catherine Moore versus, there we go, Deutsche Bank National Trust Company as trustee for Morgan Stanley ABS Capital One Inc. Trust 2006-HE5 and New Century Mortgage Corporation. Sounds like a lot of people there. Well, we only have two. Okay, counsel, whenever you're ready.
Yes. May it please the court, I'm Nicholas Vidoni for the appellants, Thomas Moore and Catherine Moore. I feel honored to represent someone who has the name of one of the patron saints of lawyers today, Mr. Thomas Moore. And this case is kind of like a law school test issue for issue spotting. Things in foreclosure law. There's four main categories of issues in this case. First category is standing. The second is proof of compliance with condition precedent under paragraph 22 under the Fannie Mae mortgage form. Third is the admissibility of evidence in a foreclosure trial. And the fourth issue is whether you get a second chance to prove your case if you didn't on the first round at trial. The issue of standing...
What is that last argument, whether you get a second
Whether
chance?
you get a second bite of the apple to prove your case. This has kind of been an issue where some appellate courts find the bank's proof deficient, sometimes because it is based on inadmissible evidence.
Are you talking about if we reverse today that they don't get to go back, or are you talking about they had an earlier trial that was reversed by concession?
If it's reversed today, they don't get a second trial on remand. That's what that argument is.
Oh, okay.
So the issue of standing is probably the largest in this case. The issue of standing deals with the first issue is there's two primary theories of standing under Florida law. The holder theory and the assignment theory are two subsets of that. Under the holder theory, you need to essentially be in possession of an endorsed note that allows you to enforce the note and mortgage. Here, that proof was lacking because we had three versions of the note produced at trial. Two of those versions of the note were attached to the complaint. The two versions that were attached to the complaint had no endorsements on it. The third, presented at trial, claimed it had an endorsement, but the witness could not say whether that was an endorsement on the original note or whether that was an endorsement that was essentially compiled onto a copy of the original note. Since the bank...
The original note's lost, so...
Yeah.
If they had the original note, then you could say, oh, there it is.
Yeah, so the issue on when you've got a lost note is you've got to prove the content of the original note.
So how do you distinguish your case from Bolus versus U.S. Bank National Association found at 210 Southern 3rd, 691?
Okay, if you give me a refresher on Bolus.
Well, it seems to be very similar to this case.
And it followed up our Marciano case where they...
Is it B-O-L-U-S?
B-O-L-O-U-S, 210 Southern 3rd, 691. You could go specifically to 694 for the notes that I'm looking at.
B-O-L-O-U-S?
Yes, sir.
November 2, 2016?
Yep, I got it. Okay.
And for your benefit, let's assume that the PSA was properly admitted in this case.
Okay.
So you have a PSA and a note transferred into the PSA, all predating the filing of the complaint.
Yeah, so there's a number of issues with regard to the PSA. One is,
But my question, and following up Judge Higbee, is get past that about whether you like it or don't like it. Let's assume it's in evidence now.
okay,
So now how is it that that's not evidence that bank had the possession of the note at some point well before?
yeah, so pooling and servicing agreement only proves one element of what you need to do to prove standing. It improves at least intent of the parties back in 2006. And a pooling and servicing agreement is essentially a game plan going forward. It's a prospective document. It's not necessarily retroactive in the sense that it tells what occurred. It's what's supposed to occur in the future.
Within 30 days.
So well, within 30 days, kind of. I mean, certain assets can be added to the trust later on, and so you have some loans coming into the trust within 30 days and other assets that can come in later.
But this loan is listed as one of the assets that's in the pooling and servicing agreement, right?
Their pooling and servicing agreement did not list this asset as part of the trust. There was a pooling and servicing agreement, and then there was a master servicing agreement, or MLS, master listing servicing agreement. The pooling and servicing agreement says specifically that the schedule of trust assets aren't attached to the pooling and servicing agreement. So what you need when you've got a pooling and servicing agreement is you need a separate document like a schedule of trust assets that tell you what the trust assets are. The bank tried to say that they have this master loan schedule, or MLS, that provided the trust assets, but the witness couldn't say whether that was for the pooling and servicing agreement. She couldn't testify as to that other than speculation.
Well, your client made payments to Wells Fargo's entity, ASC or whoever, right?
Yeah, they made payments to ASC, and
Why would he do that unless they're the ones who have the note and mortgage, or were servicing the note and mortgage?
they made payments to, there was also a loan modification with ASC, which is a division of Wells Fargo.
Right.
Proof of payments isn't necessarily something that Florida law has placed as a central issue in terms of standing. The central issue of standing is, do you hold the note, or did you receive the right of the note holder from somebody? Receiving payments is just an issue of servicing. You can be the servicer of the loan that has the right to receive payments that doesn't have the rights of a holder. It's part of the complexity that the financial system has built into these documents. Perhaps, in cases like this, that complexity has created a bunch of burdens, and maybe there's an issue as to whether that needs to be reformed. But under Florida law, you have to have the rights of a holder, or you need to be able to track your rights to enforce the note from the holder or the person who was the last holder when you're in a lost note case. The schedule of trust assets that we're talking about in this case is extremely problematic because, like I said, the witness couldn't say whether that was a schedule of trust assets for this loan. She couldn't testify that who compiled that trust asset. She couldn't testify as to when that list was compiled. It's conceivable.
Well, how could she? I mean, how would anybody do that? Unless they're the ones who actually did it.
Yeah, I mean, I think you can get somebody with knowledge as to how these documents are compiled. And that person can testify. But when you bring in the wrong witness that can't provide that testimony, then your proof is going to fall short. There's got to be someone in every single bank that can talk about how these documents are compiled. And if you don't bring that person, then it's not gonna cut it. Did I say that I was reserving 5 minutes for rebuttal?
Sure.
All right.
Unless you want a different amount.
What's that?
You want a different time? You want more or less?
5 minutes would be fine. The issue of standing, I think, who was the holder, deals with whether the note was ever endorsed. We didn't have that proof here other than speculation from the witness testimony. It's important to note that foreclosure cases aren't based on witness testimony when we have these large corporate bureaucracies that are essentially managing the loans.
Wasn't the copy of the note admitted into evidence endorsed?
There was a question as to whether it was a copy of the note. The court initially found that proof wasn't provided.
Well, there's a piece of paper that says note on it that was admitted into evidence.
Yeah,
right?
certainly up until the last page, they proved that, I mean, we basically admit that up until the last page, the page with the alleged endorsement on it, that was a true and accurate copy of the note.
Right.
The issue was what that last page with the endorsement on it, was that endorsement ever placed on the original note? The bank couldn't say whether it was, other than the witness's circular logic of, I think it was on the note because this looks like an original note.
Well, for the note to be accepted into the PSA, didn't it have to be endorsed?
That's what the PSA said,
Okay.
but the PSA also said that it needed to be on the face of the document, the signature block, if there's room, and there's room on there. So obviously, you know, this isn't a loan that conforms with the intent of the PSA. The PSA also says that there needs to be a separate document that lists, at least at the time of the trust initiation, what loans are supposed to be going into the trust, and there needs to be some sort of document that tracks possession of the note. So the question is, why wasn't that documentation provided at trial if it was required by the trust documents? I don't think that the bank has an answer to that. So the main thing about the pooling and servicing agreement is that at most can show something like an assignment under the assignment theory, potentially an assignment of the note to the trust. To do that, you've got a list of actors in a trust. You've got, in this case, New Century was the loan originator. On the pooling and servicing agreement, New Century didn't have any obligation to put this loan into the trust. Rather, Morgan Stanley was the listed depositor, and the depositor is supposed to take an assignment or some sort of transfer from some sort of loan originator, and the depositor has the obligation to put the loan into the trust. There is no proof that there's a transfer between New Century and Morgan Stanley. Then Morgan Stanley is supposed to put that loan into the trust as the depositor, and it's supposed to deliver the loan documents to a custodian who holds the documents. And then there's a servicer that's collecting payments under the note and mortgage. So you've got all these actors. The trustee is essentially the one that's supposed to be making money off of the deal. The servicer kind of does too. They're paid for their services to collect the money. But the main issue is we don't have that link between the originator, New Century, and the depositor to put this into the trust at the initiation. There's two issues of Florida law with regard to a pooling and servicing agreement. You need to have both the right to transfer it into the trust and the intent to transfer it into the trust. So with intent, the pooling and servicing agreement doesn't really say what the intent of the parties were. New Century wasn't around to testify, and there wasn't any sort of evidence through the business records as to what the intent of the parties were of where this loan was supposed to go. I think ideally, my model system for standing, because it's gotten so murky, would be complete reform of just having something like what MERS was supposed to be, Mortgage Electronic Systems, where all the big banks agree to some sort of unified system where it says we're going to keep track of who has the right to enforce a loan, and if everyone agrees that list is binding, and all you would need to do in court is show up with that list. But
Judge Altenburn, in an earlier opinion, kind of suggested that we're really getting lost too far about why somebody needs to actually hold the note at the time that the complaint was filed. And
I think there should be
it seems to
reform.
make a lot more sense to me.
Yeah, I think there needs to be reform. It's mainly an issue, I think, in the legislature's hand, because the legislature has adopted the UCC, which talks about the standing to enforce notes. You need to be a holder. The UCC is kind of an outmoded tool when you've got securitization that kind of bubbled up in the 80s and advanced in the aughts. But, until the legislature acts, we're kind of stuck with the law of standing as it's laid out.
Judge Jacobus is going to rewrite a statute in the earlier case, so maybe he'll help them out on this
Wow,
one, too.
did I? Yeah, I did, didn't I? Or what?
So, I want to talk a little bit about the elements of a lost note. There are three things that the bank needed to prove here that it didn't in regards to a lost note count. One is...
Let me ask you, this is always the one I like to ask. Your clients signed a note,
Yes.
they borrowed money,
Yep.
they got a house,
Yep.
they lived in the house,
Yep.
and they stopped paying.
Yep. And traditionally, back in the days of George Bailey, it was
kind
not
of the
very
bottom line.
difficult to prove your foreclosure cases because the banks didn't bundle and sell these loans every 2 years.
I understand that. When these cases first started, we really didn't have a lot of law on it. Because of pleading law, the way, the civil pleading law is, you plead something, you got the burden to prove it. And when do you prove it? At a trial. I'm kind of with Judge Alderman and Judge Lambert in a way. The way we did it at first, you pled, I hold the note, here's a copy of the note. All right, you show up at trial and you prove it. Well, then the fourth district had a different idea. It said, well, you got to kind of show that you owned it before you filed your suit. Well,
Yeah.
That's the way it played out. I'm not sure it's right, but it's what the law.
Well, that's the
is.
law
I
of
agree-
standing
I agree
that's
with you.
actually been
But the
around for
bottom
over
line
100
is,
years.
your people got the money, they bought the house, they didn't pay, and well, what are we talking about?
Yeah. So, certainly the issues of the complexity set up by the financial industry has benefited some homeowners, and I agree with that. And there's a moral issue, I think, that the legislature might need to address, and maybe the financial institutions need to address to curtail that.
In hindsight, they could have probably amended or created a new hearsay exception. There's a lot of things that could have happened, I think.
You're into your rebuttal now, so you can keep going, or you can reserve the rest of the time.
Well, I'll keep going, and maybe I'll save a little bit less time.
That's
two
fine.
Two other things that I want to talk about is the case of the paragraph 22 compliance. Here, the bank tried to prove that it sent the pre-suit notice of default through a wall screenshot that the witness had no clue who generated it, whether that...
Guy say, you're talking about the default letter?
Yeah.
Didn't he say he got one and signed for one? He signed for one?
I don't think he said that. I think he said he received some documents prior to the foreclosure, but he never said what documents he
It
received.
seemed, I thought there's somewhere he said, well, somebody brought a letter and I signed. Brought it to this house, evidently. I don't know. I thought he said that.
Yeah, but he never said that it was the paragraph 22. There was no link between that and the paragraph 22 letter.
Okay.
And what he could have signed is probably the getting service of the complaint. The bank refused to flesh out what exactly he received.
Okay.
And so when you've got conditions precedent, it's a burden shifting. It's not really a defense. It's actually something that shifts the burden over to the plaintiff, since it's their burden to show that they've complied with the
Pretty good
contract.
opinion on that one, I thought, about substantial compliance versus strict compliance.
Yep. But under the case of Maddle, you need to prove that you sent the document, and that needs to be done through admissible evidence. It's clear that they didn't have admissible evidence of that. There was a recent case that I do want to, that I'll be filing a notice of supplemental authority. It's Rivera versus Bank of New York Mellon. It's a July 24th, 2019 case from the second DCA that dealt with a very similar issue where it was a wall screenshot, just like you have here. And the witness, it was a motion for summary judgment that was reversed in that case. And on reversal, the second DCA said the affidavit didn't say that they knew anything about how this document was generated, so it wasn't admissible and you can't use it for motion for summary judgment. You have the same sort of issue here, except at a trial level. Also, the pooling and servicing agreement, one of the big problems here, and potentially I need to look at Bullis while I'm sitting down, but one of the issues is it isn't signed. There are certain attachments that are signed that aren't central to the agreement itself, but in this case in Maddle, it said An unsigned pooling and servicing agreement doesn't really prove anything, because if you want to say our contract proves something, you need to show that the parties intended to be bound by that contract. That intent to be bound is proven by signatures. So I'll save the rest for rebuttal.
All right, thank you.
Thank you.
Oop, hang on.
May it please the court, David Rosenberg on behalf of the appellee, Deutsche Bank. If this court has no immediate questions, I'd like to begin by talking about the standard of review. The Moores want this appeal to be a second trial. It's not, and it can't be. This court can't reweigh evidence, especially testimonial evidence. Instead,
Trial judges think we do that.
yes, they do. Instead, the question of reestablishment, including the page bearing the blank endorsement, is to be decided as a matter of fact by the trial court, not as a matter of law. And on appeal, this court is going to review it for competent substantial evidence. So if there's any competent substantial evidence in the record supporting trial court's findings of fact, this court must affirm. Additionally, as this court held in Ferry v. Abrams, great deference, it's the words this court used, is afforded to the trial court's findings of fact drawn from conflicts in the evidence and the credibility assigned to a testifying witness. Here, the main point on appeal for the Moores is standing, specifically 673.3091, subsection 1, subsection A, whether Deutsche Bank lost a note while it was blank endorsed, or, and this is language in the statute, directly or indirectly acquired ownership of the note of the loan from someone who's entitled to enforce it when it was lost. I'd also note that, as we put in our briefs, Verizo from the second DCA, circumstantial evidence can be used to prove standing. We don't have to prove a negative here. We do not have to prove that no other entity acquired ownership of the loan. All we have to do is prove that Deutsche Bank.
Well, you indemnified them in the final judgment, didn't you? I mean, if there's another note shows up, you got to pay.
Yes, Your Honor, correct. We indemnified them in the final judgment. So we're now required to prove that some mysterious unknown entity did not take ownership. And the record reflects just two owners here, New Century and then Deutsche Bank. And as I'd explain, under either scenario, the record reflects that Deutsche Bank acquired ownership under statute directly or indirectly from the entity that was entitled to enforce a note when it was lost. Before I get into the meat of that standing argument, I want to address the PSA and whether it was signed or unsigned. We averred in our answer brief that it was signed. In the reply brief, the Moores, for the first time, begin parsing through and breaking up the PSA document and saying, which is record 739 to 1202, and saying that, well, this part has some signature lines that are not signed, and this part has some signature lines that are signed. In the initial brief and below, that document was treated as one. Everybody referred to the entire thing as the PSA. And this PSA is prefaced by a signed certification from the managing director of Morgan Stanley stating that it entered into this agreement. So there's a signature at the beginning. This was submitted to SEC under gold seal. At the end of this document, there is it's amendment number 1. This is record site 1199 to 1201. It states that whereas New Century Mortgage Corporation, Deutsche Bank, labels them by their names as given in the PSA, are parties to the pooling and servicing agreement dated as of June 1st, 2006. Following that are the signatures of all of the parties to the PSA. So you have a signature at the beginning, and you have a signature at the end. The PSA is signed. It was treated as one document. In the initial brief, it was treated as one document in the trial court proceedings. So I just draw attention to that because I obviously wasn't able to respond to that parsing out for the first time in the reply brief. I want to then just quickly address Marciano and Bellus, as Judge Higbee, you noted. So both of those are controlling on this case, well, Marciano especially because it's from this court. And Bellus, citing Marciano, said that the language in section 2.01 of the PSA, and they quoted from Marciano, they said that that language provided an evidentiary basis to foreclose. The language here, while not identical, is essentially identical, nearly identical to the language of the section 2.01 of the PSA in Marciano. I also want to address the assertion by counsel for the Moores that the MLS, the mortgage loan schedule, was not part of the PSA. My colleague said that there was no testimony below that it was not part of the PSA. In fact, on record site 1317, it's of the transcript, there was testimony elicited by the Moores counsel from our witness, where the witness said, without a contemporaneous motion to strike or an objection, that the MLS, the mortgage loan schedule identifying the loan at issue, was part of the PSA that was submitted to the SEC. I apologize for all the acronyms. That is on lines 12 through 15 and 21 through 23. And finally, regarding the testimony on the letter, you're correct, Judge, when you said that there was testimony regarding the letter. That is on record site 1384 to 85. Mr. Moore confirmed that he received mail from ASC and Wells Fargo. He remembered being informed that he was in default under a loan, and he recalled receiving letters notifying him that he had not made his payments under that loan.
So he got the letter. I mean, he got the default letter, right?
Yes,
According to his own
Testimony.
testimony.
correct. And there was also the,
So whether you guys knew why, how, or who wrote it, or he got it. And he got it before the suit was filed.
yes, Your
And he
Honor.
didn't cure the default.
Correct, Your Honor.
So you're, as far as you're concerned, you're past the paragraph 22 argument from the appellant.
Correct, Your Honor.
Okay.
So then just the final thing I'd note, again, we're talking about standing and proving standing and whether the standard is too strict. Again, Rizzo from the second DCA, that circumstantial evidence can be used to prove standing. There was substantial circumstantial evidence here of our standing apart from the PSA and the MLS. With the complete payment history, which presumably you wouldn't have access to unless you actually had ownership of the loan. We've been paying taxes on the loan. Peguero from the fourth DCA says that can be used to prove standing. No payments since 2011, as we noted, and New Century's default. Nobody else is claiming ownership of this loan. The only other owner identified in the record, New Century, was defaulted. They're named for a junior mortgage.
Well, you know, they're also bankrupt too, so they're probably not gonna, just say, I sued a bankrupt entity and they defaulted, so therefore I really got a leg up. You know, I get the academic discussion, but that's probably not
It is
probably
not.
not your best effort there.
Correct, it is academic. So if this court has no further questions,
You know?
I'd request that this court affirm. Thank you.
Okay, thank you.
Thank you.
All right, let's see how much time you ended up with here.
49 seconds.
49 seconds.
All right, let's see how quick it can be. All right. Bolus, I looked it up. It's distinguishable from this case because the pooling servicing agreement and the schedule were admitted without objection. So there was an issue as to whether that was an authentic document, like this case. Also, there was no lost note issue in Bolus, which was central in terms of proving whether the note was ever endorsed. They came up with an original note that was endorsed in the Bolus case. To clarify what opposing counsel said, the MLS, the witness said that, oh yeah, we got this from the SEC, and then the witness then testified she didn't know if it came from the SEC. She didn't know where it came from, and so she contradicted her later testimony. That this case, the trial, I lost count of how many times the witness contradicted herself. In terms of the business records exception, the witness testified that on the boarding process, which is what's required under the Callaway case, you need to prove that there is some sort of procedure to authenticate the trustworthiness of the documents from the previous servicer. And the witness said that verification was literally impossible. So they never proved that part of what they need to under the business records exception under Callaway. And if the court doesn't have any questions for me, I'll leave.
All right, thank you, Counsel. You used your time. Okay, like I indicated earlier, we'll take a break now. Anybody wants